So a very good evening to everyone. Today we'll be discussing one of the Supreme Court case law that have come out in the last financial year. And this case is all about Supreme Court examining the circumstances under which a refund could be withheld by the department and some of the key observations which Supreme Court made with respect to this particular case. So we'll see all these things in this particular presentation, and without wasting much time, let's start with it. Credits to EPSIBA for working on this presentation. These are the legends that have been used in the PPT. So once we upload it, it will be useful for your reference. This is a schema upon which we'll be approaching this presentation. So obviously we'll have the facts of the case at first. Then we'll see the issue that was actually raised before the Supreme Court. And we'll also see the order that was passed at various appellate forums. Then we will observe the contention of the parties. Parties refers to the department as well as the assessee. Then we come to the most important aspect, the observations of Supreme Court, and finally we'll end with the conclusions that have been made by the Supreme Court in this particular case. So we'll start with the facts of the case. Well, I guess there is some issue with respect to loading the facts of the case. Anyway, I'll just narrate you the facts of the case, and once we upload the PPT, you can have a look at that. So the name of the assessee is Vodafone Idea Limited. So as we all know, Vodafone Idea Limited is into the business of providing telecommunication services. So it has filed its return of income right from assessment year 14-15 till assessment year 17-18. So for 4 assessment years, starting from 14-15, 15-16, 16-17, and 17-18, for all these 4 assessment years, it has filed a return of income claiming a refund. Most important point, it has filed its return of income within the due date, but it has claimed a refund over there. So what has happened with respect to first 3 years is, that is a 14-15, 15-16, 16-17. The first 3 assessment year, what has happened is notice under section 143.2 has been issued. So what is this 143.2 notice all about? So once we file our return of income, the department, the assessing officers might scrutinize our return. So before they actually commence the assessment procedure with respect to scrutiny of our returns, they generally issue a notice to us, and that notice is what we generally refer to as 143.2 notice. So this 143.2 notice, very important point. Only if you understand this point, we'll be able to correlate this case going forward. So this 143.2 notice was issued with respect to assessment year 14-15, 15-16, and 16-17, and not in respect of assessment year 17-18. But in respect of all these 4 years, starting from assessment year 14-15 till assessment year 17-18, all the returns, the assessee has claimed a refund. But 143.2 notice was issued only in respect of the first 3 assessment years and not in respect of the last assessment year. A very important point. Just keep that in mind so that it will be useful when we actually discuss this further. So assessee has filed a return of income, he is claiming a refund, but it was not provided the refund which is legally entitled to within the time limit provided in the Act. So deeply annoyed and aggravated by the action of the department in not providing the refund, what happened is the assessee filed a writ petition before the High Court. So the writ petition was filed stating that I want my refund for all the 4 assessment years along with interest. So that was the stance of the assessee. What happened then? Then the department filed a response to the writ petition stating that there were multiple issues going on against the assessee. For example, there was a special audit going on, there was huge demand that was pending, there was scrutiny assessment which was pending for various years, and again there was issues with respect to return of income that has been filed. Say for example, there was transfer pricing adjustments and there was capitalization of license. There were multiple issues with respect to returns that was filed by the assessee. That's why the refund was held back, because if they're going to grant the refund in spite of all these issues, it would be prejudicial to the interest of the revenue. That's why the refunds were held back. So these is the brief facts of the case. Unfortunately, it's not appearing on the slide, so I have to narrate it. But once we upload the PPT, it will be available at your disposal. So we'll go further. So what was the issue that was actually raised before the Supreme Court? The first point, whether it is necessary to process the return under section 143.1 when a notice under 143.2 has already been issued. What is this point all about? So for the benefit of all, I would just like to give you a small background. Whenever you file a return of income, it's subject to processing. So whomever it is, whomever is going to file a return of income, your return is going to get processed. So what happens in this processing, it will just check for some arithmetical accuracy, some apparent consistencies. Then it will state the demand payable, and in case you have claimed the refund, it will acknowledge the refund that is payable. So this is something which will happen for all the returns. But the question here that was actually raised before the Supreme Court is whether it is necessary to process the refund under Section 143(1), specifically when a notice under Section 143(2) has been issued. So as I said, no, before the scrutiny assessment commences, a notice under Section 143(2) notice is issued. So in such circumstances, whether it's actually required to process the return under Section 143(1). That was the question first question that was actually put before the Supreme Court. Second, even if it is held that the processing of return under Section 143(1) is not required, whether a separate intimation is to be given to the assessee stating that the processing of return has been kept in abeyance. So these were the two questions that were actually put forth before the Supreme Court. We'll move further. So as I said in the previous slide, there are no decision of the lower level forums. Why? Because the assessee directly filed a writ petition before the High Court. So the case did not go to the ITAT or CAT appeals or AO. It was straightly presented only before the High Court. So we have the decision of the High Court alone. So what High Court concluded is the right to claim refund cannot accrue when a scrutiny assessment pursuant to 143(2) is pending. So when a scrutiny assessment is actually going on, the assessee would not be entitled to refund merely because of processing of return under Section 143(1). That was the stance of the High Court. We'll move further. So we'll see the contention of parties. So we'll quickly see this and we'll delve into the important aspect of this presentation. So what were the arguments of the revenue? First point, there is no requirement to process the refund under Section 143(1) when a notice under Section 143(2) has been provided. So when 143(2) notice has been given, there is no processing under 143(1). That was the first point. Second point, if they're going to grant the refund, in spite of all the problems that is pending against the assessee, it would be prejudicial to the interest and it would be detrimental to the interest of the revenue to get it back in case there is a tax payable. And that's why the department held back the refund. That was the second point. Third point is it's up to the AO to exercise the discretion whether to carry out the assessment under Section 143(1) or a scrutiny assessment after issuance of notice under Section 143(2). It's completely up to the discretion of the assessee. Completely up to the discretion of the AO. Assessee cannot come and argue that the processing has to be carried out under 143(1) and refund has to be granted. No, assessee can never do that. So these were the three important stands of the revenue, and based on these three stands, what happened was the revenue invoked the powers under Section 143(1)(d) and 241(a). So don't worry, we will see all these things. 143(1)(d) and 241(a) is the crux of this presentation. We'll see this particular two sections in the observations of Supreme Court. But what happened was the revenue invoked these powers and declined processing of returns under Section 143(1), and the refund was withheld. But what was the argument of the assessee? The assessee stated that the respondent neither did process the return for assessment year 14-15 to 16-17, nor it exercised the discretion under Section 143(1)(d). So if the department is going to withhold the refund, then it's up to the obligation of the department to intimate the assessee stating that my refund is getting withheld by the department, but there were no intimation made by the department as such. And if you see, as I said in the facts of the case, a notice under Section 143(2) was issued only in respect of the first three assessment years. But in respect of assessment year 17-18, even the 143(2) notice was not even issued. So in spite of no action being taken in respect of assessment year 17-18, my refund was still withheld by the department, for which I wasn't provided any intimation at all. So that was the stance of the assessee, stating that my refund should be granted back to me along with all the interest which I am legally entitled to. So we'll get into the most important part of the presentation now, that is the observations of Supreme Court. So as I said, there are two important sections over here. One is Section 143(1)(d) and Section 241(a). So to understand this better, we will start with the legislative history behind this. So what was happening is the assessees were claiming enormous refunds, and once the processing of returns got over, they were getting back the refunds. But eventually, when the case was taken up for assessment, and once the scrutiny proceedings got over, there was a huge tax payable, and since the department already gave the refunds back, it was difficult for the department to collect taxes back because there was a tax payable based on the scrutiny assessment, but the refund was already granted based on processing of returns. So department was finding it difficult to get the taxes back. So that's why we have Finance Act 2012, Section 143 1D was inserted. It's clearly stated that it shall not be necessary to process the ITR under Section 143(1) if a notice has been issued. So once a scrutiny assessment notice has been issued to the assessee, there is no requirement to process the return. So indirectly, it's saying that once a notice has been issued under Section 143(2), even though you have claimed a refund in your income tax returns, you will not be eligible to do that, because in first place, the processing itself will not happen when 143(2) is filed. So that was the important part of Section 143 1D. But it did not stop there. We had some amendments taking after that. So in Finance Act 2016, it addressed one of the flaws that was there in Finance Act 2012 amendment. What was that? Finance Act 2012 bluntly stated that there would not be any processing of returns. But to be frank, the processing of returns should be there. So what Finance Act 2016 said is, it specified a period within which the processing of returns should mandatorily happen. So it stated that the processing of returns is not required when Section 143(2) notice has been issued, but it has to be processed before issuance of final order, final scrutiny assessment order. Once the scrutiny assessment is completely over, the AO is obliged to give the final order. So at the time or before the issuance of final order, the processing of ITR has to mandatorily get over. That was Finance Act 2016. But again, there was a flaw in this particular section. What was that? So even in genuine and legitimate, or even in bona fide cases, the refund was getting withheld by the department merely by issuance of notice under Section 143(2). I might be eligible for refund genuinely, or due to some bona fide reasons, I might be eligible for refund. But the department, what they did was they just issued notice under Section 143(2), and they would keep my refund in abeyance for a long period of time, even for months, or sometimes even for years. So this was resulting in genuine delays in processing the refunds and processing ITRs. And to address this, Finance Act 2017 brought an amendment stating that 143(1)(d) will not be applicable right from assessment year 17-18 onwards. So what does it mean? So assessment year 17-18 onwards, 143(1)(d) will not come into picture. So do you mean like department will not be able to withhold the refund at all? No. That's where a new section came into picture, that is Section 241A. So 241A has a set of procedures to be followed, and only then you'll be able to withhold the refund. And these are not introduced with the intent of protecting the assessees and preventing unnecessary harassments against the assessee. So what are those conditions? First one, the AO should actually form an opinion that granting refunds is something prejudicial to the interest of the revenue, and such reasons has to be recorded in writing. And third point, very important point, it has to obtain a prior approval of Principal Commissioner of Income Tax and Commissioner of Income Tax. So it has to obtain a prior approval of the concerned authorities. Only then it will be able to withhold the refunds. So earlier, merely by issuance of 143(2) notice, the department were withholding the refunds. But going forward, department has to follow a specific set of procedures, at least the conditions that have been mentioned in 241A. Only then it will be able to withhold the refunds. So these two are the most important sections of this particular presentation. Hope you have got this. We'll go further. So what was the observation of Supreme Court? So as I was saying right from the beginning, there were two major processings that were happening. One is processing of returns under Section 143(1), and other the scrutiny assessment. So it's better we appreciate the difference between two. 143(1) is something very summary in nature. and 143.1 is actually carried out in order to identify the apparent inconsistencies in the returns and other documents that we have submitted. To give you an example, say the tax auditor in its respective form is providing a disallowance, and the same disallowance is not being provided in your income tax return. The income tax department during the processing, this will be immediately identified during the processing of returns, and would be immediately intimated to the assessee. They will not wait for this particular apparent inconsistency to be revealed to the assessee till the scrutiny assessment. They will immediately highlight this particular issue to the assessee and ask them for justification for this. But if you see 142.3 or 142 or 143.3 assessment as a whole, the main objective is to identify whether the assessee has understated the income or overstated the loss, or assessee has avoided any payment of tax. That's the main objective of section 143.3 is all about. So if you see the powers or the scope or of 143.3 is comparatively astronomical with respect to the scope of section 143.1. So in respect of assessment year 14, 15, 15, 16, 17, 14, 15, 15, 16, 16, 17, the first day assessment years, the scrutiny assessment is already in place. So when a scrutiny assessment is already in place, which is broader in scope, which is something very astronomical, which is in comparison to that of 143.1, which provides a much more deeper probe and a much more important consideration of facts, then in such cases, the assessee merely demanding the refunds merely based on a summary assessment which is carried out under 143.1 is something incongruent or illogical. So that was the stance of the logical reasoning provided by the Supreme Court. And this is further substantiated by the section itself. If you carefully look at the section 143.1d, it uses a non-obstante clause. It states that notwithstanding provided anything provided in section 143.1. So whatever provided in section 143.1 will not be applicable once the powers under section 143.1d is invoked. So both logically as well as legally, Supreme Court held that once a notice under section 143.2 has been issued, the processing of returns under section 143.1 is not required for a specified period of time, and it shall be kept in abeyance. So this is the most important judgment of this particular case. So Supreme Court arrived at this both logically as well as through the legal provisions. So we'll see the next question was actually put forth before the Supreme Court. So the assessee was arguing that even though I'm declining the right to get my refund, even though my refund is getting withheld, I should have the right to receive an intimation from the department at least. Department didn't inform me that my refund is getting withheld. Department didn't even make any intimation. That was the point of the assessee. Supreme Court observed the section very carefully. So 143.1d states that only and 143.2 notice should be issued. It doesn't mandate any other separate intimation to be sent. 143.2 is itself a sufficient indication, sufficient intimation to the assessee, and that itself is enough to trigger the consequence of section 143.1d. So Supreme Court concluded that there is no requirement to send a separate intimation apart from section 143.2. So this was evident from the Income Tax Act with respect to that particular section itself. So going on further, so all these what we discussed was from assessment year 14-15 to assessment year 16-17. But assessment year 17-18 onwards, a different regime was altogether followed. There was no requirement to issue 143.2 notice at all, because as I said in the legislative history slide, from assessment year 17-18 onwards, a new section had come into picture, that is section 241A. So once you satisfy those conditions, in section 241A, that is actually withheld the refund respective of the fully issued notice and so avoiding the date, yes, once you upload the PPT, you can actually look at the dates for a better understanding. So what was the final assessment order that came up? So with respect to assessment year 14-15, a refund of 733 crores was being entitled to the assessee. For 15-16, there was a demand of 580 crores. So department argued that there's a different, there is a demand in respect of different assessment year. We'll set off both and we'll give the refund of only the difference. But Supreme Court clearly opined that no such an action has been earlier initiated. So in case no action has been initiated against the assessee with respect to set off of refund and demand, Supreme Court stated that it will not opine on that and directed the department to give the refund of 733 crores within the prescribed period of time, and also directed the department to complete the assessment for the pending years. So this is what the logical and legal conclusions with respect to this particular case. And for a quick recap, we will see these conclusions as well, so that we get a comprehensive understanding. So in respect of assessment year 31 ending 31/3/17 or before that, for notice issued under section 143(2), it shall not be necessary to process the returns, obvious, and there's no requirement to provide you separate intimation. 143(2) notice itself is a sufficient indication altogether, and 143(1)(d) does not contemplate issuance of any such intimation or any further application of mine that processing of return should be kept in abeyance. No, 143(2), once you issue 143(2) notice, everything is sufficiently complied with. And with respect to assessment year and 17/18 onwards, there is no requirement to issue 143(2) notice itself, because you have to comply with section 241A, the specific conditions provided over there. Then you can actually withhold the refund. So I think that's it. Thanks for listening to me.